good morning. Thank you guys. First of all, I want to say thank you guys for coming. I know this is our first one out, and so for anybody who made their way out today, we so appreciate it. We also have some people that are joining us on Microsoft Teams because we realized everybody couldn't be here in person, right? And so first of all, I want to say thank you all for coming. We appreciate you. And so we're going to talk a little about what we're doing today. We're only going to be an hour. And so let me just introduce myself. For those that don't know, I am Director Chiron Richardson. I am the Director of the Division of Housing Preservation. And so what we decided to start, because in talking with constituents as well as landlords, some issues that we saw that arose was just a lack of understanding and a lack of information. It is our due diligence and our job to make sure that everybody fully understands what this office does. That helps you because then it keeps you from wasting time trying to get us to do something that we're not able to do. And then we can specifically make sure that we're able to do what you need to get done because we're here to serve the public. And so our main concern, our main goal is to make sure that we do our best job to serve the public. And so with that being said, today is one of many series that we're starting. And so we're calling these educational seminars, right? Because our office does a lot of stuff. And if you're a resident, which you are of Jersey City, you know, sometimes the name can be deceiving. You hear this name, you hear this name, but then you'll be surprised that though the name says housing preservation, most people, what are you preserving, right? So give us some insight. What exactly does housing preservation do? And so that's what we want to do with these seminars is to let you know exactly what we do so that we can better serve you. We wanted to begin with our rent control because that's a hot button topic right now. That's probably going to be the next one because another thing that we're seeing that's related to rent control is tenant petitions, right? Because a lot of tenants, what do I do if I feel like my rent is being illegal? What do I do if I feel like I'm not getting the service that I deserve? So we felt like it would be good to start on that one and then possibly next month we'll talk a little bit more about rent control. Is that all right? Now let me say this. We're gonna hold questions to the end. So I saw you coming. I saw you coming. So you just give me some time. I want to just go through the PowerPoint, and then at the end we will have a session for questions. Okay? All right. Okay. So let's talk about it. So the first slide says the Division of Housing Preservation. This is an overview. The Division of Housing Preservation is responsible for administering and enforcing those requirements provided in Chapter 254, Chapter 255, Chapter 260 of the Jersey City Municipal Code. Some, and I want you to know this is not all that we do, but just giving you just a little sneak preview of some of the things that we do. So some of the primary functions of our division include enforcing the Jersey City Rent Control Ordinance through the Office of Landlord-Tenant Relations. Within the Office of Landlord-Tenant Relations is also the Bureau of Rent Leveling. We maintain the public officers' abandoned properties list and the vacant properties list and collect foreclosure registrations. We've also recently started conducting lead-based paint inspections, pursuant to PL 2021 C-182. That's the state law. We also are required to do the issuing of hotel, motel licenses, as well as issuing short-term rental permits. And again, it reads quick, but it's a whole lot more to all of those things that this office does. Okay? Go to the next slide. All right, this morning's agenda. The purpose, we're going to be talking about the purpose of tenant petitions. There are two types of tenant petitions, right? So as tenants, if you're tenants today, we want you to know that there are two types of petitions that you have the right to apply for. Number one is failure to maintain service petition. Number two, which is an illegal rent petition. So those are the two types of petitions that our office deals with. The failure to maintain services. Tenants may file this petition if their landlord fails to maintain the same standard of service as was provided at the inception of the lease agreement or as required by the law, right? And so thus the name, failure to maintain services. There are certain services that the landlord is required to make sure the tenants have, and these services will be provided to you at the inception of your lease agreement. Next one, illegal rent. Tenants may file this petition if they wish to question the legality of the rent charge and or rent increase imposed by their landlord. So you have every right to know whether the rent that you're paying or the rent that you're being proposed to be increased is legal per the Jersey City Municipal Code, okay? Let's talk about the process. Reviewing the process of filing a petition and how to determine is rendered by the Bureau of Rent Leveling. Appeals, Rent Leveling Board, and Superior Court. So once the petition is appealed, these are the next steps. They go before the Rent Leveling Board, and then after that, we'll talk a little bit about that. They go before the Superior Court, okay? The purpose of tenant petitions. Jersey City Rent Control Ordinance 260-9, powers and duties of the Bureau of Rent Leveling. The Bureau of Rent Leveling, under the direction of the Rent Leveling Administrator, shall have the following powers and functions. The first one, to remedy violations of this chapter by adjusting rentals, ordering rebates, and bringing appropriate legal charges as provided in this chapter. Second thing, to accept complaints from tenants of illegal increases, provided that all claims are sworn to and acknowledged by a person authorized by law to administer oaths. We'll go to the next slide, and if you don't mind, I'm gonna take a drink of water. Okay? So let's talk about processing petitions, okay? A tenant claiming that the rent they are being charged is illegal may file an illegal rent petition with the Office of Landlord-Tenant Relations, Bureau of Rent Leveling. A tenant seeking a rent reduction due to the landlord's failure to maintain service, something's in my way. Due to the landlord's failure to maintain services or to maintain service, can file a failure to maintain service petition. There was something I couldn't read there. Now, the steps to filing the petition are as follows. And let me see, how do I move this? Did he leave? Y'all know how y'all got the little pop-up in the corner that's in my way. Give me 1 second. I don't know if this mouse is working. There we go. Hold on a second. Let me go back. There we go. Okay, sorry about that. Okay, here we go. All right, the steps to filing a petition are as follows. The appropriate petition is filed through the City of Jersey City's permitting and licensing portal. The tenant shall submit any and all documents supporting their claim alongside their petition. The tenant serves a copy of their petition and its supplemental documentation to the landlord. The landlord is given also an opportunity to respond. Now, this is important. I want to stop real quick here, because I think sometimes what I want the public to understand is that our office is called the Office of Landlord-Tenant. Sometimes I think people mistake the office as the Office of Tenant only. But our office is not just tenant advocacy. We're here to do what's fair on behalf of the landlord and the tenant. So when you come to our office, please keep in mind that we're not just here to serve the tenant, we're also here to serve the landlord, right? And so that's why the landlord must be also given an opportunity to respond. Next, a hearing officer will review all documentation provided by both parties, as well as any in-house information to determine if the tenant is entitled to a rent credit, refund, or reduction. In cases of failure to maintain the service petitions, a hearing is conducted amongst all parties by the Bureau of Rent Leveling. A determination is rendered providing the hearing officer's finding. So if you file a failure to maintain service petition, there is also a hearing that comes along with that. And so anybody, familiar with judge shows, Judge Judy or any other of your favorite shows, it's similar to that, to where a hearing officer will hear both sides of the party, and so you both get an opportunity to just share your testimony about what you filed the petition for. You get an opportunity to talk as well as the landlord, okay? All right, let's talk a little bit about determining illegal rents. And if I'm moving too fast, please let me know. It says to determine if a rent charge or rent increase imposed is legal, there are several documentations that the Bureau reviews to ensure that landlords complying with the provisions of the Rent Control Ordinance. Some of those documents provided for the Bureau's review in illegal rent cases may include rent receipts, right? So if you're following an illegal rent petition, we may require that you provide us with rent receipts as proof of the rent that you paid. Of course, the lease agreement, notice of rent increase, any and all correspondence amongst the parties. That includes the tenant, the landlord, and any legal representation. Again, we're trying to get all the documentations to make sure that whatever determination we make is fair and right for all parties. Some of those in-house documentation reviewed by the Bureau in illegal rent cases may include annual landlord registration statements. Landlords are only entitled to increase during the years in which registrations were filed with the Bureau in rent-controlled properties. Let me get another drink of water, please. So I want you to understand what that means. Every year, your landlord is required to submit a rent registration with our office. If they do not submit that in that year, they are not entitled for a rent increase. So that's why that's so important, okay? It says any and all rent increase applications approved by the Bureau of Rent Leveling or Rent Leveling Board, i.e. vacancy capital improvements, and hardship applications. So there are some other things, we'll talk about that in a future educational seminar, that a landlord is legally, can legally do to increase their rent, right? So they make any certain improvements to their property. They have a right to make improvements, but even though they make the improvements, there still has to be an approval from our office or our division before they can charge those rents, or to make sure that the rents that they charge are still legal, okay? And then rent control exemption status of the property. In most illegal rent cases, the Bureau reviews the rents charged for a unit going back 6 years. That is very, very important, right? So when we determine whether your rent is legal or not, there is a 6-year look back so we can figure out what the rent should be charged, 6 years, okay? And in going back 6 years, what we're doing is making sure that the rent is consistent with the statutes of limitations in the state of New Jersey. Let's move on. Determining a landlord's failure to maintain service. To determine if a rent reduction is owed to a tenant due to their landlord's failure to uphold services required by the law, or as provided at the time the lease agreement was entered. There are several documents that the Bureau reviews to ensure that the landlord's complying with the provisions of the rent control ordinance. Some of those documents provided for the Bureau's review in illegal rent cases or failure to maintain cases include, again, rent receipts, lease agreements, notice of rent increase, pictures and videos of violations and issues within the unit. So if you have any, this is where you can do your investigating. So if you have something that you can prove as, you know, and I'm trying to think of certain cases where, so I know I've had times where people like the bathroom was not fixed, right? So people have given me videos, giving me pictures, showing me proof and evidence that they issued a complaint to their tenant, the tenant didn't fix it, and then they'll show me pictures of either when it was fixed or the fact that it was still not fixed. So things like that, okay? Any and all correspondence amongst the parties. Extermination invoices, boiler repair invoices, PSE&G bills, etc. So if you're in the case, hey, Anna, if you're in a situation where, let's talk about, so we said extermination, right? So landlords are required to provide those extermination services. Well, then they will also be required, and again, this is both sides, issuing their evidence, whether or not they contracted somebody to come in and do the extermination or not, because if they didn't do that, and that was a part of their duty, you might be entitled to a reduction in rent, okay? And then it says where a tenant has filed a failure to maintain service. A hearing is conducted amongst all involved parties. Again, that's the landlord, the tenant, and any legal representation for either party. Both parties are given the opportunity to answer questions and provide testimony in support of their allegations. Rent reductions are appointed in cases where the hearing officer finds that the landlord did indeed fail to remedy violations in a timely manner. So let's talk about that just a little bit, okay? Because there ought to be a timeline. You as a tenant have the right to have the services that you are paying for every day. And so if a landlord fails to provide a service and it's an extended amount of time, then there may be a situation where you are owed a rent reduction for that time period which those services were not provided, okay? It says where the landlord was negligent to their property, so we're talking about that failure to maintain service, and or where the landlord has proven themselves to be unresponsive to their tenants' requests for assistance with hazardous or inhabitable conditions, right? And so not only are tenants, you have the right to have your any issue service, you also have the right to be in communication with the landlord. At no given time should you be silenced. There should not be silence when you're trying to get something done. So even that is something we take into consideration. Appeals. Okay, so now both petitions were filed. Afterwards, after determination is rendered, so now, whether it be an illegal rent or failure to maintain service, our office issues a determination. Both the tenant and the landlord will get a copy of said determination. After that determination is rendered, either party, either the tenant or the landlord, may appeal that decision to the Rent Leveling Board within 15 days of the decision. Again, why is that important? Because sometimes when people get a determination from our office, what they don't understand is that there's still an appeal process. And so you may get a determination from us and in your mind think, okay, that's the end. Well, on both sides. Your landlord can appeal that within 15 days, which means that though you have a determination from us, it's not final if it has been appealed. Now, if neither party appeals, then the determination stands. But you have to keep that in your mind that there is an appeal process, okay? Goes on to say a party appealing this determination must include in the written notice of appeal, A, the decision or part thereof from which review is sought, B, the factual and legal basis for the appeal with citations to the record, i.e. registration statements considered by the Office of Landlord-Tenant in its final determination. So what we're saying is that there must be factual evidence why a person is appealing. The fact that I don't like the determination, that's not enough to say, well, this is why I'm appealing, I just don't like it. There has to be some type of factual evidence to prove why you feel the determination is not right. It says, please note, the notice of appeal must be served upon either of the other party. So if the tenant wants to appeal, the landlord it must be served into the landlord and vice versa. It says, except for good cause shown, no appeal shall rely upon any issue of fact or law or upon any documentary evidence not presented to the Bureau. Okay, so nobody can pull a surprise of something that was not presented to the Bureau. Where the appeal has been accepted, the parties are notified of the Rent Leveling Board hearing date and may appear and argue their positions. So now you've appealed. It's no longer in our hands. It goes before what's known as the Rent Leveling Board. You will be notified of when you will be heard, when your case will be heard. It's normally the third Thursday of the month. Sometimes we've had to adjust. Those meetings start at 6 p.m., right? Because we are mindful that people are working. And so it is a time where most people should be able to attend. It is at that point that you get to plead your case before the Rent Leveling Board. They are a fresh set of ears, and maybe they'll hear something that we didn't hear, and they have the power to make determinations even if it does not align with the determination from our office. It says the Rent Leveling Board may reverse, affirm, or even modify the hearing officer's determination. So now you've gone before the Rent Leveling Board. And let's say in your case, we sided for the landlord. Let's say that happened. Let's say the Rent Leveling Board also sided for the landlord. Still not over, because after the Rent Leveling Board makes their determination, there is a third appeal that can be made to Superior Court. So you need to understand that even though it goes before the Rent Leveling Board, both parties still have the opportunity to appeal the decision. Again, that's important because when people hear determination, if they don't understand that there's another step that could happen, they'll want to expect something that we legally cannot give them because there's the process of appeal that it still must go through. Okay. It says, then either party may appeal. the rent leveling board's decision, and then the next step, and then the last step is to Superior Court. Okay? Now, hopefully, again, I didn't move too fast, but I said I was going to open up the floor for some questions, and I already saw one hand go up, but then his hand was up, and then her hand is up, and so I'm going to ask, this is our manager of the Office of Landlord Tenant, Ms. Jana. She's going to come, and she's going to answer your questions, and then I'll come back at the end.
Good morning, good morning. Does anybody have any questions? Let me see. I know that, yes.
For the rent, you were saying for the determination letter for an illegal rent, the office I thought he said the rent leveling board determines it, and then if you want to appeal, it goes to the rent leveling board again. But so is it the office
So,
that's determining it?
yes, so the Office of Landlord-Tenant Relations is also, within that office is the Bureau of Rent Leveling. So our hearing officers are sworn in by the Rent Leveling Board. And we basically, our determinations are recommendations to the board. So if the parties agree on what our office determines, then it's not filed, an appeal's not filed to the Rent Leveling Board. But it can be appealed to the Rent Leveling Board. Once it goes before the Rent Leveling Board, they can say, we agree with the office's determination, and we're affirming that recommendation, and that's what we're honoring as the rent for the unit. And in cases of applications or, hardship applications, they'll affirm the approved amounts or the recommended amounts.
Now, he also said that while you're going through the rent leveling board petition, you're allowed to talk to the landlord to get whatever documentations that you need to get for that petition, right?
Us specifically as a division, or you're saying the
Like
tenant?
The tenant. If I'm the tenant, I'm allowed to speak to my landlord while I'm filing the illegal rent petition.
Well, yes, you're allowed to speak to your landlord regardless of filing the petition or not with our office.
Until it gets to the final appeal. If it goes to Superior Court, then
Once it goes to Superior Court, we don't have any jurisdiction over how you communicate with your landlord. We always recommend that any communication, especially where there's potential litigation, you're doing it in writing. So we would always recommend that any communication with your landlord, you're doing it, via email, via text message, or with the assistance of an attorney.
okay, thank you.
You're welcome. Anybody else? Yes.
Can you give me, is there a formula for affordable housing?
So we are not affordable housing. After this, I can give you my card and we can discuss, referrals for affordable housing. But as far as rent control, there is a cap and it's 4%. We receive our number from the Bureau of Labor Statistics. So if, for example, the number that they're providing us is 4.2, the landlord cannot increase the rent more than 4%. They cannot increase it by the 4.2% if the property is subject to rent control.
So in Jersey City,
Yes,
the max you could raise each year
Right.
would be 4%.
unless the CPI, the Consumer Price Index percentage, is less. So if the Bureau of Labor Statistics is providing us with 3.6%, that's the number that you would have to honor. Right,
Got it.
right.
Got it. And anything under 5 units is, no, over 5. Over 5? Yeah, 5
Yes.
and over is rent control.
Properties with 5 or more units are presumed to be subject to rent control. There are specific exemptions, and we'll have another session where we go through all of those exemptions and, how we, recognize those properties. Okay,
Oh, yeah, that's what I was gonna ask. I was
Sure.
gonna say, is there a limit, because it's a 4% increase. If it's a 3-family owner occupied, does he have a limit?
no. Any properties with 1 to 4 units, regardless of the occupancy status, if the landlord lives there or not, is exempt from rent control. Right.
When you fix the apartment, you expect somebody got to fix everything, kitchen or bathroom, you give you a special to increase the rent.
Yes, so within those cases, you would submit either a vacancy capital improvement or a capital improvement application. So capital improvement is if the unit is occupied while you're doing the renovations and if you're doing it throughout the entire dwelling. And a vacancy capital improvement application is if the unit is vacant when you're performing that work. With the vacancy capital improvement applications, the way that the ordinance is written right now, you can submit that application to our office prior to the a new tenant occupying the unit, or after a new tenant occupying the unit. It's always best to do it before the tenant moves in.
But when you copia for the tenant, you can increase the rent.
You can increase the rent based on, so if your previous tenant was paying significantly less and you did renovations that would approve maybe a $200 increase in between tenancies, once that new tenant comes in, you can charge $200 more, but you would want to make sure that the application that you submit to our office supports a $200 increase. Yeah, but you would want to take pictures, you'll submit a vacancy capital improvement application, our inspector will go out and they'll affirm that all the work that you're claiming on your application was in fact, completed, and our office will issue a determination either agreeing with the proofs that you provided and approving those amounts, or it may be adjusted depending on the invoices that you provide in support of your application. Yes? Yes.
So maybe on to what you were just saying, does that vacancy capital increase or the capital improvement increase, does that ever impact actual destabilization of a rent control building or unit? Let's say, for instance, if a building is rent controlled and let's just say their last registered rents for one unit is $1,000, and so this landlord submits this application and says, hey, I did all these wonderful things here, nobody's lived here, so does that then make just that unit applicable for a larger increase? Does it limit how much they can increase?
So for vacancy capital improvement, there is a formula. There's a specific formula that the landlords are entitled, that they have to follow. So it's $1.35 for every $100 of the first $5,000, and it's $1.55 for every 100 of everything after the first $5,000. So if somebody spends $5,000 in renovations and they provide the proofs for that and the invoices, they would get approximately like a $67 increase. So that's only to that unit. It's not to the property in its entirety. Where the property is affected in its entirety is if a capital improvement is done. And, for example, like a boiler system is replaced. That would then, there'd be a depreciation period. So if there's tenants there, they will gradually feel the effect of that increase, but it's not all at once. There's a depreciation period so that it's manageable for the existing tenant. If that makes sense. Yeah, but vacancy capital improvement, essentially you don't have a tenant that's in that unit. So anybody that's coming in after that work is performed, when they're signing that initial lease agreement, they're agreeing to pay the significantly different rent because the unit is renovated.
Got it. And I think the context, and I'll keep it brief to ask another question, is if there is a building with a rent controlled status.
Hello, I'd like to know if they.
I'm sorry, give me 1 second.
Want to be,
I'm sorry, just give me 1 second. We just have someone in the middle of answering a question. Just give me 1 second. No, it's okay.
There isn't any provision to essentially do some repairs and then turn around and say, well, cool, it's now valued at double the amount, like this unit is now worth that. I guess I'm trying to capture that quickly, if that's even a possibility, or if that's something that these provisions control.
So with the vacancy capital improvement, that's definitely a way for landlords to increase the rent a substantial amount in a small period of time. But it's supported and approved by our office based on the work that they put into that unit. With capital improvements, like I said, there is a depreciation period for that, so the tenant doesn't feel that all at once. And it's also divvied up amongst all the units in the property. So if if the amount is $25,000 that's approved for the capital improvement and it's a 12-unit property, it's divvied up amongst the 12 units. So it's not all those renovations just allocated to one specific unit. Yeah. I'm sorry, someone that's attending online had a question?
yes, I'd just like to know if the seminars want to be uploaded somewhere for future viewing.
Yes, so we'll upload the PowerPoint to our webpage. You'll also be able to access this video through, I believe we're posting it to the Jersey City YouTube channel. And I will, if you have any questions, I do believe that I have your email. I think that you emailed landlord tenant. We'll be sending updates to anyone that has inquired through our email. Okay, does anybody else have any other questions? Yes. No, it's okay, no problem.
Talked about the rent leveling board increases, and the failure to maintain, it was around the appeals. So when it comes to bumping it up to a superior level, is that really only around the failure to maintain services petition process, and if both parties are actually in continual disagreement, that it's just like, this is out of our hands, we're putting it here, or is there ever an authority within the Office of Landlord Tenant to say, this particular case might be, egregious or, something that it's just really out of our privy to make a determination on, and maybe it should go to.
Superior Court. Yeah, so in those cases, our determinations any determination that we render will make sure that we're covering what's in our jurisdiction to address. So if there are issues that are a civil matter that we see arise while we're reviewing the case file, we will cite that in our determination and say that's a civil matter that's beyond the jurisdiction of our ordinance, and you would have to then at that point either seek legal counsel to take it to that level. Yeah. Anybody else?
Yes, I have a question.
Sure.
Can you go over the process for capital improvement while the tenant is there? So for example, do I need to apply and get approved first before I do any work?
Yes,
Or do
so
I start the work?
So there is a pre-application for capital improvements. We will be going over that in a separate session, but just because we're on the topic and to give a brief overview, there is a pre-application that needs to be submitted, and there is a formal process where a hearing is done with the tenants in the unit. So it's definitely a more extensive process than vacancy capital improvement. But if you want to send your information into the chat, I can send you an email with the appropriate person to reach out to for that, and he can assist you.
Thank you.
You're welcome. Is there anything else?
Can I just jump onto his question?
Sure.
What if it was there was an emergency, just like how you had mentioned with the replacement of a water boiler?
So for emergency repairs, again, I believe that you could still file the capital improvement application. I don't think that our hearing officer who reviews those cases would be, opposed to reviewing an application if a pre-application hasn't been filed, but there would still be a hearing with the tenants. Okay, anyone else? Let me just make sure that we don't have anything in the chat here. Okay, so I don't think that anyone else reached out through the chat. So if there's any other questions, now's the time to ask.
Can I just get the name of the contact person?
For the capital improvements? Yes.
For affordable housing.
Oh, sure.
I understand. The formula is extremely confusing.
The formula I explained was anything that's related to rent control and the rent control ordinance, not to affordable housing.
So can you give me the?
Yeah, sure. I have my cards over there. I can give you one. Okay. All right, I think that we will end the session.
Yeah, no, I'll come.
Okay.
Okay. All right. So y'all, give it up for John answering those questions. But again, we just want to say thank you. This is the first of many educational seminars, right? And the questions that we get, they also help us determine what should be the next one. As of right now, we are going to be talking the next one about rent control. I believe that's going to be the next one. But then, of course, VCIs, capital improvements, vacancy capital improvements will be another seminar. But again, the main thing for those that are here, those that are watching this later, is just we just want to make sure that you understand this office is committed to transparency, right? There's nothing we're trying to hide. We want to just make sure that we're doing our best job to serve everybody. tenants and landlords. But if you have any other questions, you can always reach out to my office. We'll answer any questions to the best of our ability, and we'll do our best to point you in the right direction, because we realize whether you're a tenant or whether you're a landlord, you've invested in this property. You've invested in it as somebody who's renting, because this is your home at the time. You've also invested it if you're owning it. And so on both cases, any type of issue that you're facing, it's an issue that's going to hurt you or help you one way or the other. We keep that in mind. And so that's why we do our best to make sure that we do it right the first time, right? So sometimes we might take a little bit longer, and then unfortunately, we are not fully staffed. We have a small staff for the number of things that we do, but with the staff that we have, we work really, really hard to make sure that we're doing our best job to serve the community that we are fortunate to serve. So with that being said, we want to say thank you guys for coming. We'll send out the information for the next one once we get everything wrapped up. And in between time, feel free to send us an email, send me an email. You do not have to wait till the seminar to get any information that we can give you, okay? Again,